Hi, this is Kaery with Kaery Concealed in the Active Self-Protection Extra channel. This week is number 2 in our series, Use of Force Files and Trials. And this week we're going to talk about self-defense claims.
Today's video was brought to us by Mantis. The Mantis family of products is integral to ASP staff building handgun and carbine skills and are your most economical and fastest path to improvement in your skills too. Whether you choose the X10, the Laser Academy, the Blackbeard, or use them all in concert, they will help your practice be more effective, efficient, and fun. Go check them out, pick up a unit, and thank them for sponsoring today's video.
Welcome back. Just a quick review. Last week we talked about a case that I recently had where it was a big case, huge case, and I wrote a huge report for it, and that all charges were dropped. And so the woman is back home with her kids now, and life is much better for her than it was when she was incarcerated. This week, I thought we'd talk about self-defense claims and what is unique or special about self-defense claims. So I've found that most of my learners think that anyone who acts in self-defense, that they can't be charged with a crime if they truly acted in self-defense. But a prominent firm of criminal defense attorneys on the West Coast says, and here's a quote, "We regularly see people charged with assaults and other crimes when they are acting in self-defense." And this is a firm of lawyers that do a lot of self-defense work for private citizens, criminal defense lawyers. So in my state, there are two fairly prominent cases. I don't know if they made national news or not, but they certainly were West Coast news. And one of them was the Gail Gerlock case in Eastern Washington, and the other was the Jared Haw case in Western Washington. And both of those individuals used force in self-defense. Juries found, the finders of fact found that they did use force justifiably, and they were both acquitted. They found their uses, the juries found their uses of force to be lawful under self-defense. I'll tell you just briefly about both of those cases, but you can go look them up if you want. The Gail Gerlock case was in Spokane, Washington, and it was around 2013, 14, 15, somewhere in there. And I believe it went to trial in 14 or 15. But Mr. Gerlock was walking out of his house early one morning to the driveway to get into his Chevy Suburban and take his wife to work. And as he walked out of the house, he noticed an individual on the driveway that was getting into the vehicle. The car was already running, but the individual was standing outside the vehicle door waiting, as if waiting for someone to come on the driveway. Anyway, when Mr. Gerlock realized that somebody was there, he heard the door behind him close, and his wife was behind him now outside. He knew that the door was closed. To get back in the house, that would not be an easy, quick thing to do. About that time, he turned and looked, and the individual was in the car and driving away. And Mr. Gerlock explained that he saw something that looked like this, backlit, silhouetted in the windows of his Suburban. And it looked like a gun pointed back at him, and he thought that's what it was. And so he drew his firearm and fired one round, and it was strange that it even impacted the individual. I know a number of different experts that tried to redo that. I forgot the word I'm looking for there, but anyway, tried to replicate that exact case or the incident, that shot, and they couldn't do it. So the round bounced off, the bullet bounced off the seat post and a car seat as well, but it did result in the death of the individual that was driving away. Now, what the news reported, and for the 2 years of the case before it went to trial, it was reported that Mr. Gerlock shot a man that was driving away in his vehicle, and he only shot him because the individual was taking the vehicle. But that when trial came, that's not at all why Mr. Gerlock decided that he needed to use lethal force. He needed to use lethal force because his perception was that he faced a deadly force threat, and the jury agreed with him. There's more to that case. But anyway, I know a couple people that worked on that case, and based on what I know of the case and the discovery I saw, I would agree with their opinion. So more to it than that. So you might want to look up some information on that if you want more. The other case in Western Washington is the Jared Haw case. And Jared Haw was a young student at Washington State University. It's kind of a long story, but I won't go into details. Anyway, he was eventually being punched by 4 to 5 women, and he was trying to push them off of him. In the process of that, another individual felt that it looked like Mr. Ha was punching the girls when he was just trying to push them away. The individual that saw the incident was chasing after him along with some of the girls, and it resulted in a mess. And Mr. Ha did the best he could, but he ended up having to use force, lethal force, in the form of a knife. And it was interesting to me when I read about the case, some of the discovery for that case, that he attempted a defensive display of the knife, was hoping that would deter the attack, but it didn't. But the jury found that they found that any reasonable person in his shoes would do exactly what he did. What was interesting to me about the Jared Ha case is he was a student at University of Washington. And within 1 day of the incident, he was kicked out of school, suspended from school. And 2 years later, when the case went to trial and he was found not guilty by means of self-defense, the university told him he could reapply. And if he was accepted, they would take him back. So as a student. So Mr. Ha lost 2 years of his life, and that trial cost his family and he about $40,000. The Gail Gerlock case that was in Spokane, that cost the Gerlock family about $300,000. Now, what's interesting about the state of Washington is in Washington state, there's a special verdict form for self-defense reimbursement. And if the finder of fact finds your use of force to be lawful under self-defense, the defendant has the right to be reimbursed by the state for reasonable legal fees, lost wages, and other fees associated with their defense. It's the judge who decides the amount to be reimbursed. So in the Gail Gerlock case, my understanding is I did not see the actual check for either of these cases, but that's what news sources cited, that in the Gail Gerlock case, it was about $300,000, and the Jared Ha case, $40,000. Now, what's interesting to me is other states have laws that allow acquitted defendants to seek reimbursement for their legal expenses, but it's a different process in most states. So the question that I think is interesting to think about is, for those two individuals, their claim of self-defense is decided by the judge. The judge decides if there is enough information in discovery that warrants the jury to receive a self-defense instruction. And if the judge says, no, there isn't enough information in the discovery of this case, and if the attorneys on both sides, however they argue the case before the judge, before trial. So I've had a case where the judge found that it was not self-defense, and the judge did not give the jury a self-defense instruction, which is sad in that case, because in that case, my review of discovery was that it was, and several other people that reviewed it as well, who are consulting experts or consulting specialists, said that it was a justifiable use of force. So even if you use, so I have a lot of students who think that, yeah, well, if I use self-defense, or if I have to use force in self-defense, it's going to be okay, because if it's justified self-defense, I'm going to be okay. I'm not saying you're not going to be okay, but it's going to be a long, arduous slog through a mess. And only if everything aligns perfectly, and I mean perfectly in most cases, the judge finds there's enough evidence for there to be a self-defense claim. And like I mentioned, I have had a case myself personally. My very first case was the judge did not authorize a self-defense instruction to be given to the jury, so they weren't even allowed to factor that as a claim. And in those instances, imagine what that would be like. You're not able, now if you can get on the witness stand and you can talk about that, that you feel it was self-defense, you acted in self-defense, but if the jury doesn't have that instruction, that's not something they're allowed to even factor into their decision. So what do you think? I talked about the case last week where the young mom was asleep in her own home, was attacked by an individual while she slept in her bed, and her process was almost 3 years long. In both of these cases, the Gail Gerlock case and the Jared Ha case, they were about 2 years long, almost 3. So the punishment is the process, right? Even if I have a case, I just got it a couple weeks ago, actually, and the young man, I won't go into details now because everything hasn't been signed. I just found this out last week. But once it's been signed, I'll be able to tell you a little bit about the case. But this young man has been in jail since June. And yes, he accepted a plea deal that's very favorable and to him, but he's still been in jail for 4 months. 4 months. Imagine loss of job, probably all those lost wages, and that case doesn't go to trial, right? So it's not like he's able to be reimbursed for his lost wages or his attorney fees. So it's important that as self-defenders, and especially for those of us that are instructors, I kid you not, I just had lunch with a friend on Thursday last week, and she's an instructor, and she was telling me that she had recently taken a class from someone at a local range, and that instructor was teaching that it was important when you're coming out of holster. She was using an outside the waistband, like a race rig, basically, that when you come out of holster, that you start prepping the trigger of the gun while you're coming up out of holster. So don't join and then prep, but start prepping here. And she asked, why do you want us to do that? Why is that a good thing to do? Now, it's important to remember that her instructor was a police officer in California for 27 years before retiring and becoming a firearm instructor for private citizens. But when she asked him that, her instructor's answer was, better to be carried by, or better to be tried by 12 than carried by 6. And that's where the conversation ended. And that shocked me. Absolutely shocked me. I'd hoped that we were past that. At least I hoped we were past that coming out of instructors' mouths in this space. But I know none of you do that. But just know that there are folks out there that do. And so when we give information like that as instructors, and I'm sure, I have no doubt, I know of some information I gave that was absolutely not great information at all in the early days when I first started teaching. And it was hopefully nothing like that. At least my perception is it wasn't anything like that. But it's important that we remember that they're going to listen, our learners are going to listen to everything we're saying about this. And it's important that we be informed about the process in our own individual state and in our own individual jurisdictions. What is the climate like in your jurisdiction? Do you have people you can find that out from and ask questions? I'd encourage you to do that. So I look forward to talking with you next week. Next week, we're going to talk about the use of force standards, and that'll be part number 3 in our use of force files and trials series.